Welcome to this talk on Biodiversity Net Gain. My name is Oliver Bussell and I'm a partner in the commercial property team at Rix & Kay. The offices are spread around Kent and East Sussex, and I specialise in planning and related areas of law. The Environment Bill deals with a very wide range of topics relevant to the environment in the life of this country after its departure from the EU. And today I'm going to discuss some of its most important provisions, those relating to biodiversity net gain. The Environment Bill fulfills an obligation under the Union Withdrawal Act of 2018 to protect the environment, and it was the subject of consultation carried out in 2018 and published by the government a year later. An amended version of the Environment Bill was published immediately after the general election, and after a hiatus across the spring and summer, it returned to Parliament in October, completing its Public Bill Committee hearing on the 26th of November. So despite Boris's jibes about newt counting, biodiversity net gain is definitely back on the agenda. The expectation is that the bill will become law during the course of next year, and that's obviously of great interest to many of the firm's clients at Rix & Kay. The big change set out in the Environment Bill concerns biodiversity policy in England. Previously, the law focused on mitigation. The idea of net gain, by contrast, aims to leave the natural environment in a measurably better state than beforehand through habitat creation or enhancement after avoiding or mitigating harm as far as possible. It's Section 95 of the bill, amending Section 40 of the Natural Environment and Rural Communities Act 2006, that's the starting point here. This restates the general biodiversity objective so that it now makes reference to the conservation and enhancement of biodiversity, not just the conservation of biodiversity. The Act then goes on to impose some fairly hefty plan-making obligations. First of all, any public authority which has any functions exercisable in relation to England is obliged to consider what action it can properly take to further the conservation and enhancement of biodiversity. Now, those obligations must have been complied with to relatively tight timeframes within a year from the date on which the section comes into force, and then a review must have been completed every 5 years thereafter. Section 95 obliges authorities to have regard to local nature recovery strategies. This is another creature of the bill, which puts spatial planning for nature on a statutory footing. These are manifested in two documents: statements of biodiversity priority for an area and local habitat maps. The purpose of these is to establish the opportunities for recovering or enhancing biodiversity within a local area. Local authorities are also obliged under Section 96 to produce biodiversity reports to contribute to a better understanding of local protected sites, priority habitats, and priority species. So, stepping back, the amendments to the 2006 Act make local authorities ready to police the general biodiversity objective by requiring them to look proactively for opportunities for conservation and enhancement in the local area. And clearly, legislating in this way will help to highlight those areas of land that might offer good opportunities for the off-site mitigation that is allowed under separate provisions in the bill. The rest of Part 6 establishes how opportunities for biodiversity net gain are to be established across development sites. So, what's new for developers? Well, the bill aims to improve biodiversity in two really crucial ways. First of all, and most famously, the 10% biodiversity net gain requirement on new development. And secondly, and part of a means of achieving this, through conservation covenants. Section 92 of the bill inserts an entire new schedule into the Town and Country Planning Act 1990. And it's paragraph 13 of that new schedule, Schedule 7A, which imposes a default standard planning condition on planning permissions in England. This is what's known as a Grampian condition, which is to say that it's a condition which is negatively worded and which prevents development from taking place until something has been done. In this case, a biodiversity gain plan has been submitted to the planning authority, and the planning authority has approved that plan. Now, the plan is site-specific, and in each case it must meet the biodiversity gain objective. And a site meets the biodiversity gain objective if the biodiversity value attributable to the development exceeds the pre-development biodiversity value of the on-site habitat by at least the relevant percentage. That has been set for the time being at 10%. The pre-development biodiversity value, well, that's the value on the date of a planning application, or in default, the date of the grant of planning permission, as established by using the standard metric. The post-development biodiversity value is the projected value of habitats needed by the local planning authority to determine whether the proposal satisfies that 10% objective. And again, this is to be determined by applying the metric to the developer's plan for the site. So the metric, this all sounds very mysterious. What is the metric exactly? Well, the metric itself is a huge topic and one for specialist conservationists strictly, but essentially this is a tool for measuring biodiversity losses and gains on sites using a standard methodology. And so it's really a means of deciding whether the 10% net gain can be established on a site or not. As far as the mechanics of assessment go, users of the metric identify the site boundaries, divide the site into parcels of different types of habitats, and input information about the habitat type, condition, and size of each area. The metric assesses the quality of the site based on habitat distinctiveness, condition, strategic significance, and connectivity. It quantifies the value of the site by translating that information into biodiversity units. Scarce and declining habitats we usually score more highly than more common habitats. And when a user needs to estimate the value of future habitat, the metric will also assess the difficulty of creating or restoring habitat, taking into account the proximity of the compensation site to the impacted site. And a development achieves biodiversity net gain if it has a higher score after development, taking into account the value of any enhanced or newly created habitats than before. The openness and accessibility of this metric, especially given that it is in its second iteration currently, metric 2.0, is not clear at present and is yet to be published, but this method of assessing biodiversity levels and projecting net gain does seem to be becoming well recognised, at least, long before there's any legal obligation in statute to apply it. Now, although, as I say, that's not strictly law, it does seem pretty central to dealing with and understanding biodiversity net gain. So I've included mention of it here for that reason. But going back to the mechanics of the legal regime being set up here, we've got a couple of interesting features. We've got anti-avoidance provisions. So where activities are carried out without permission or of a kind specified, which basically serve to degrade a site artificially, then the value will be treated as what it would have been had those things not been done. And there are a couple of points here, I think. First of all, it might be quite tricky to determine whether works which have the effect of artificially lowering the biodiversity assessment of a site were carried out maliciously or with the intended purpose of lowering the value of the site, or whether they were done for some ulterior purpose, and possibly a purpose which was quite legitimate in planning terms and all other respects. Secondly, there's actually an even more dangerous, there's an even greater danger here for landowners in a piece of pre-existing legislation. The possibility that a criminal offence may have been committed in lowering the biodiversity net gain value, and that would happen if any protected species had been affected by those works, and that would be under the Wildlife and Countryside Act 1981. So there are fairly standard anti-avoidance provisions, as you would expect. As far as exemptions go, well, the draft legislation initially looks slightly alarming for developers. There are three clear categories of exemption. First of all, development consented by development order. Secondly, urgent Crown development. And thirdly, the catch-all, development of such other description as the Secretary of State may, by regulations, specify. Well, this is not simply a parachute to help government deal with the unforeseen consequences of a mandatory Grampian condition, making contact with reality, though I'm sure it will be very useful for doing that as well. Looking back to the July 2019 consultation response, it made clear that there would be qualified exemptions for a number of situations and outright exemptions as well. We don't have those in law at the moment. They are set out for the time being only in that consultation. And the qualified exemptions are for smaller sites, minor residential developments, which might be subject to longer transition arrangements or a lower net gain requirement, minor development, where there would be simplified assessment in consultation proposals, and that would apply to developments of fewer than 10 dwellings on a site under 1 hectare or on a site of less than half a hectare. Sites containing no habitats to start with. These would not be required to deliver compensatory habitats, though through biodiversity net gain, but they might be required to incorporate some green infrastructure, continuing current practice under planning policy. As far as outright exemptions go, these would be for some kinds of permitted development, householder applications disproportionately impacted by the requirement, such as residential self-build, certain brownfield sites that don't contain priority habitats. We are told that NSIPs, nationally significant infrastructure projects, will be exempt, as will marine development for the time being at least. Now, clause 93 of the bill introduces a publicly accessible biodiversity net gain site register. This is a record of land suitable for habitat enhancement, which can be subject to obligations. Clause 93 is then the springboard for a whole further set of regulation to be laid out: eligibility, applications, amendments, inclusion and removal of land from the register, fees payable, and that is all to follow in legislative terms, so watch this space. At clause 94, we have this idea of biodiversity credits, which essentially allows the purchase of a credit from a third party in satisfaction of those mitigation requirements set out in the amended Town and Country Planning Act. In other words, allowing you to buy off the biodiversity net gain condition, which will otherwise prevent implementation of your development. I think it's interesting to note here that under this draft scheme, the local planning authority has a discretion as to when, and indeed whether, to allow the purchase of biodiversity net gain credits instead of providing the mitigation on site. It's possible, I think, that regulations will set some kind of test or default parameters as to when use of the biodiversity net gain site register can be accessed, but that's just speculation for the time being. Unfortunately, the strong preference of all government guidance so far is that mitigation, in the first place, should take place on site for preference, with only the fallback alternatives of a combined on and off-site contribution, and finally an exclusively off-site contribution. could be quite a serious thing for a developer, because it could make some sites riskier to develop, at least until the developer could be certain either that the council would agree to off-site contributions, or that the developer was able to obtain 10% more land around the perimeter, perhaps, of the development to ensure that it was nonetheless able to meet its biodiversity net gain objective on site, delivering that 10%. So perhaps the most interesting thing from a lawyer's point of view in the bill comes in the conservation covenants, which are at section 108 of the bill. And these are agreements between a landowner and a responsible body, and they must have a conservation purpose, and they must be intended to be for the public good. They can require a landowner to do or omit from doing something, or likewise allow a responsible body to do something or omit from doing something on their land. And the conservation purpose is extremely widely drafted, actually. It's to conserve the natural environment of land or the natural resources of land, or to conserve land as a place of archaeological, architectural, artistic, cultural, or historic interest, or to conserve that setting. A conservation covenant is a local land charge, and it will have much the same effect as a Section 106 obligation in terms of binding those deriving title from the original covenantor. Another statutory exception to the rule that positive covenants cannot run with the land. The difference, of course, is that Section 106 is actually a pretty narrow and prescriptive piece of legislation, as it describes what sort of positive obligations may be entered into. Conservation covenants are, as I've alluded to, not narrow at all. They're extremely wide. They're not limited in scope to biodiversity. And in fact, they go wider still in terms of binding the setting of land, not just land. Enforcement of a conservation covenant may be by specific performance, injunction, damages, and contractual damages. And we can see in the creation of these conservation covenants that a new market for mitigation land is being established here, as well as using the other methods I've described of identifying land in need of biodiversity enhancement. So a kind of summary at the end of that: biodiversity net gain is of course not new, but the extent and ambition of the concept as set out in this legislation is new, and it represents a challenge to landowners and developers alike. And I think it underlines the rather curious position we're in after leaving the EU, that although we are vehemently insisting upon our rights as an independent sovereign nation to diverge from European regulatory standards, in fact, our own social and political imperatives are pointing in many ways towards the embrace of a more rigorous regulatory regime. It will be very interesting to see, especially as secondary legislation feeds through, to what extent the controls I've been discussing here are to be qualified. And as the Environment Bill progresses towards the stage of being adopted as an Act of Parliament, we at Rix & Cave will continue to report on its evolution and the implications for our landowner and developer clients. I hope you've enjoyed watching this, and do please get in touch with us if we can help you with property or other commercial matters. Thank you.